The challenge to the impugn opinion fails and the writ petition is dismissed.
WPC 103/2019.
No infirmity could be detected in the decision of the tribunal. Writ petition is dismissed.
ক্যামেরাটা বহুত প্রোডাক্ট হবে কি আবার উঠাই দিও না
উঠাই দিন
21 matter. Why are you fixed in the month of December 2025? There's an order. Okay. Pre RM Chaudhary, learned counsel for the petitioner, has expressed some personal difficulty and has prayed for adjournment. Para? In view of the above, matters are adjourned to be listed on, we give a date. On 8th of December, 8th of January, 8th January. Yes. 24 years. Yes. Item 8. Item 8, your name is not there. Okay. On a request made on behalf of the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit. Yes. Hmm. Hmm. Okay, is it? Okay. Inform the other side. Our request for adjournment has been made on behalf of Sri P.K. Tiwari, Learned Senior Counsel, appearing for the respondents. Respondents 2, 3, 4, 5, and 6. On the ground, on medical grounds, para. Considering the same, matter is adjourned to be listed after the winter vacation. You tell us. Winter vacation, para. On request, list on 21, 20 28th of January, yes. They want some time. When do you want? After vacation. Other side, agreed. Okay. On a request made on behalf of Sri D. Saikya, Learned Senior Counsel for the respondent number 1, matter is adjourned to be listed after the winter vacation. Don't listen. Sri B. D. Chaudhary, Learned Counsel, has made a request on behalf of Sri D. Saikya, Learned Senior Counsel for the respondent number 1, for adjournment on medical grounds. Para? On request, list after the winter vacation. Yes. Tell us on ऊपर में on request मत लिखिए, बाद में लिखेगा. On request list on 19th of January. Okay. Motion. When? Tomorrow. What is the urgency? Okay, motion tomorrow. Okay, no problem. 22 years. You're for whom? Okay. On a request made on behalf of the GST, matter is adjourned to be listed after the winter vacation. Interim order passed earlier to continue till the next date of listing. 5 years. Okay. On a request made on behalf of the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit. Motion. Motion is urgency. No. Sorry. You approach the registry, not by this. Sorry, we cannot help. We cannot help. Out of turn hearing by the motion, accept motion, you'll have to have extreme urgency. Is it something is going to happen tomorrow? Then that is the extreme urgency. Sorry. Yes. Admission, what is the urgency? Huh? Why? Sorry. Yes. Contempt, fresh matter. Contempt, what is the urgency? Sorry, there is no urgency in contempt. There is no urgency in contempt. The result is going to the jail. There is no urgency in sending somebody to jail. Yes. IA. When did you file? IA for? IA for? It has not been listed. Okay, we'll have the IA. When do you want? Friday. 17 years. What is it? $15. Sorry. 15 matter, no adjournment. No point. Don't make a mention of a 2015 matter in 2025 end of. Whatever is it, we are not going to adjourn 2015 matter after 10 years. Writ petition. It is very embarrassing. Don't make this kind of request. We can accommodate, that's a different matter, but we will not adjourn matters of 2015.
Item 23, supplements. But in this case, from the back, our passport was a the lordship will find that page 14. The certificate issued by the Miller recipient standard authority of India. Page 14.
Yes, Mr. Sharma, what is this? Okay, anyone appearing?
Taking loan from the bank, doing business on the street. There is no matter. But basically, still, but I have not thought of right. The losses doesn't vary. Municipal,
Let us see the notice. 31.
from the government. And people of the government company, not really, not certain. If I have actually developed plan to inform you that second within that to talk for the union fast food business providers in front of Vishal Makamat station to
See, your installation doesn't appear to be a permanent installation. Remove it. It has got wheels. So in wherever you want, wherever you want, you can install your stall. Where? We don't find any other. Where? See the photographs. Page 30, we don't see any other stall. Where? That is not a stall. That has got the cycle wheels. And we do not know what action has been taken against them. Perhaps action has been also taken against them. That negative equality, Mr. Sen, you know about it. Judgment will come later, Mr. Sen. First facts. Let us see. Let us see.
Last paragraph you are lost in the
This is not going to have any application in your case. This we know about this case. Don't show a case which has got different facts. These are totally different. They're totally different. That's totally different.
That is the difference. Otherwise, the subject is same.
You don't have you don't have a right. You have to show a right that you. First show us your by what authority you are standing there. By what authority? Where is the authority by which you have installed your stall there? Now, where is the letter? Under the Act, you can have a stall anywhere. Let us see the trade license. 1(6). Now, where is the place where you'll have the stall? Trade license is not is only for enabling to. Yes.
Commuter takes it that has been it is absolutely open area. Whereas some other people are bending over that temporary.
When were you giving this license?
860.
Oh, you. Now, how have you put your stall there? That we want to see that communication by which this Mr. Sen, page 27, 28, your annexures. Does it show that it's in the open market? It
is near the market. This is the station road. On the street, I am bending. The Supreme Court said in some case 890, 1.5.
First, you have to show that communication by which you have been given the permission to have a stall there. Yes.
Under the 2014 Act, actually,
Sorry, heard three BKs and Learned Council for the we are issuing notice. You don't want notice to be issued. Then why are you arguing? If you don't want notice to be issued, you don't issue notice. But we are not granting any interim order. Sorry, no interim order. Heard three BKs, heard three BKs and Learned Council for the petitioner who is aggrieved by an order dated 27/11/2025 issued by the Sri Bhumi Municipal Board. Full stop. It is the case of the petitioner that he or she is running a fast food stall from the said location in terms of a license, a trade license, and a registration certificate issued by the competent authority. Full stop. Para. Let notice be issued, returnable by 4 weeks. Housing and urban, who will be taking? You'll be taking. Sri H. Sharma, Learned Additional Senior Advocate, accepts notice on behalf of respondents 1 and 2. Extra copies, 3, 4 registered, not speed post by AD. Steps within 2 days. 3, send the Learned Council prays for an interim order. Full stop. This court has, however, on perusal of the materials on record, this court has, however, not been shown any document by which this particular location was allotted to the petitioner. Full stop. The license also appears to be of very recent origin. Full stop. In that view of the matter, this court is not inclined to pass an interim order at this stage. The prayer for interim order may be reconsidered after appearance of the respondent numbers 3 and 4. Yes, that's it. At times, some orders are required to be passed. At times, some orders are required not to be passed. Public interest is very important. Yes, next. Yes, Mr. Dutta. Yes. What is the matter? Compensation of? Who are you, Mr. Dutta? You had acquired the land. He's the contractor.
Dumped on his soil and therefore he is suffering loss of crops, etc. My preliminary objection is there.
You have come to a writ court. No, you can approach the civil court. This is neither acquisition, it is only a damage. It's a pure and simple damage, and you have to prove damage. You may have a case, but are we in a position to assess the damage? Perhaps not. You will require to adduce evidence. Okay, let Mr. Chaudhary come. He's there or not? He's there in the court. Okay.
Item 3.
Item number 3. Yes. Okay. Is there any dispute with the facts? Yes, who's appearing?
BSNL.
Hmm.
The basically, is a set platform. From last occasion, there was a investment.
How is BSNL connected?
Because the, our, the transformer was, well, I mean, it was under our.
But he died out of electrocution. Or the injury was. Oh.
So I let, because on last occasion, what was discussed in the fact that.
Hmm.
Now he's seeking for an enhancement. The question is that regarding the enhancement part, whether this court can go into further details of this thing, because there is only, the report says that he went on his own volition to that part. Now the question is that the transformer was ought to be looked by the gate, now there is
No,
a-
so far as APDCL is concerned, they have certain guidelines for payment of compensation either for death or for injuries. That part I think you have fulfilled.
That part we have to. Now, question, enhancement. He's seeking for enhancement of that enhancement.
Why don't you approach the civil court?
That this could not be the.
Because this is only a kind of a solace. This may not be the actual compensation or the actual damage which you have suffered. You need to prove this.
My only difference is 200, so I have to 100% disability and minimize the 85%.
Now that Honorable Supreme Court judgment is pertaining to what case? Let us see. Let us see page. No, where is the decision? Please. That case had originated in a 226 proceeding. Mr. Mola, that origin was a 226 proceeding. In that case, the case originated by a 226 proceeding or by a, let us see. No, it started with a writ proceeding or with a civil proceeding. Let us see that. What is the citation?
Then 17, PH 115.
2017, 3 SCC. Which paragraph? Yes.
Right, the incident in question about duty negligence of the state and its authorities. And hence, the state was declaring the liability to compensate the respondent for the offense obtained by the state. It clearly mentioned that the state rightly did not silence this, and hence we need not go into practice. The High Court further held and in all the I think that in regard to the family background of the respondent and further respondent's excellent performance and the brilliant scrutiny in study. You would have recently our British traffic control purpose in this platform. We find no trouble to interfere in this finding of act, which is our opinion is based on proper material. The High Court, however, further awarded 10 lakhs plus loss of companionship, life benefits, pleasure, and happiness. Rupees 10 lakhs for pain and suffering, mental distress, trauma, and discomfort, and inconvenience. Rupees 10 lakhs for attendant nursing expenses, and lastly, rupees 5 lakhs for taking artificial property names and future medical expenses. In our considered the award of compensation under this board date appears to be on the higher side and is not supported by anything.
Yes, how do you respond to this, Mr. Das?
This judgment is very, first of all, the finding of fact, that is what was the finding of fact is not for us. Here in the petition as to what was his actual income, what was his fee.
Okay, we'll have this after the vacation. This will require some deliberation. But we have to distinguish it.
And
No, given by which court? No, in what proceeding? No? Writ proceeding.
first is maybe part of this case will be discussed.
Our just concern, we like to have your views. These are all tortious liabilities. And once it is tortious liability, the matter of assessment becomes really difficult for a writ court. Whether he may be justified, it may not be justified. But whether this is the forum where one can establish his claim without there being any avenue for reducing evidence. We are only on the forum part. We are not on the quantum. He may be justified in claiming this marriage, but whether writ court can delve into those aspects. And kindly see the jurisdiction which the Himachal Pradesh High Court had. When can we have this? What is the other one, Mr. Mullah? No, give the citation, please. CPR. What is CPR? Huh? That is CPR means what? Consumer. It went from a consumer vote. Let us see, perhaps it has gone from a consumer. That had gone from a consumer case. That will be different. Mr. Mullah, we are not, till now we are not disputing the amount. You may be entitled. We are only on the aspect whether we can make an assessment of the compensation.
And the
And
inquiry,
income, my lord, in that case also 8 years, why my lord? Income, my lord, that aspect issue will be, as in my case also, that my lord.
consequently, inquiry report says that the child is very peaceful and on his own volition when timely transformed. So that is the negligence on whose part, that would be in
That, they have paid my lord, my report inspection, my inspector also has, and my lord. That's what they did.
That's what is being said.
Otherwise, my lord, more than 4 lakh, I am still under treatment, my lord. One hand is imputed, the other one pollution is not good, my lord. He cannot pick up anything. Now this.
Mr. Mullah, you are not getting our point. We are not disputing. You are not disputing on this. You may have a very good point, seeking higher compensation. But are we in a position to adjudicate? Where is the evidence? How do you how do you assess the evidence? How do you appreciate the evidence? Where do they get the chance to cross-examine the witness? Okay, we'll have it after the vacation. We'll try to, this is what. Let these two decisions be on record. We have extra copy. If you, you can give it on the other day also. No, CPR is also from High Court. I do not know. It's a writ petition. That is what we are trying to see. Appellant approached the High Court by filing writ petition under 226. Please look into both the decisions. We need your assistance. CPR. Raman versus Uttar Haryana Bijli Vitran Nigam. Other one is Naval Kumar. Okay, you can place this on the next date. Okay, you keep it. Heard the learned counsel for the parties. Full stop. It is submitted that the matter can be taken up for disposal at the admission stage. Full stop. Para list for admission. Immediately after the winter vacation. No, Bihu vacation. In the third week of January. 2026. Okay, next.
Item 6.
Yes, Mr. Hussain. Affidavit filed, madam. For release. Okay. Okay, then we'll have it. Heard Sri M. Hussain, learned counsel for the petitioner. Para. Also heard Miss M. Bormon, learned state counsel, and Sri A. Bhattacharya, learned standing counsel, Revenue Department, who has submitted that there are certain developments for redressal of the grievance of the petitioner. Full stop. They have also placed on record an order dated 29/11/2025 issued by the Office of the District Commissioner, Dhubri, which should go to show the said development. Para. In view of the above, matter is adjourned to be listed after the winter vacation. Full stop. On the next date, the up-to-date status is required to be apprised by the learned counsel for the respondents. On request, list on 21st of January 2026.
Item 7.
Seven, yes.
By way of negotiated, there was a scheme of the garden on the paper, where 106 tea gardens were invited from the. They were appraised the first fee, whereby direct prices are negotiated, and based on that, acquisition is made.
You are a tea garden or what? Okay. Mr. Nayak, yes, we can take it up for disposal. Public. Yes, Mr. Goswami would be appearing. Okay. Can we take it up for disposal?
There are this one very small. No, the issue is, I mean, it's point of one. The issue here is prices were negotiated, which takes half of the payment was made. Thereafter, they taking over the land, the road has been constructed. Now they're saying they will revisit the earlier assessment and they'll do it as per the revised value. So they're basically changing the price. That's the issue. After having made the sign on all come.
Yes, can it be done, Mr. Goswami? If there's a concluded contract, and after conclusion of the contract, can you alter the price or reduce it? Somebody asking for an enhancement is different because of change of thing, circumstance, increase in price, escalation.
If you have been the provision of 2050 what the award is clear. In that situation, is saying that apply. It's the negotiation with the party. And if you are found that a stipulation issue with the concern party. Probably that was not that long, and subsequently the particular of the review. This negotiation, I mean.
Negotiation between the petitioners and whom? It is not a very kind of a private kind of a negotiation where somebody is buying land from A, is buying land from B. If the district administration through a committee has negotiated and arrived at a price, matter has been done, completed, then you reduce the price. Is it permissible? How much is the reduction now?
That's that was what the. Now the 94,000, less than a lakh.
And what is the what are the grounds for such?
Done in April of 2020. Now thereafter, the zonal valuation of T was brought down in August 23. So they say now that the zonal valuation has come down, you calculate it as per this. By this time, they've already taken over the land.
This is not fair. You have to, Mr. Goswami, even if we examine this matter on a retrospect, the rates which were available at that time, unless there is some gross hanky-panky which you have to project and establish, you have to abide by the contract. If by a subsequent notification the zonal valuation has been brought down, will it affect something which was existing earlier? Mr. Nayak is saying that the DC had committed some error. Error has to be examined from that context, that in that point of time, was it an error? No, if there was some change in the rates, zonal valuation, after the contract has taken place, then it will not cover. It cannot, you cannot bring in those aspects. It will be extraneous.
Definitely box to say that we will not demand more than this. Or to say you for. Possible to ask other opinion. In that case, now to some regulations to address for the measurement.
Now, for those you can take all steps. No, if there are manipulations, some fraudulent activity, those will not. But here that is not there. That is not there.
In fact, PWD had also signed order. I already put that I that PWD has not that PWD.
No, Mr. Goswami is there for the district administration. Yes, tell us. Go ahead today or when? Burden should not be extended. Let us finish it today. All of you can sleep peacefully. Matter is over. Yes. Tell us, what is it? Yes, what is it? Give us the facts properly, okay? 92. Who are you first? You are 6 in numbers, petitioners. Okay. 92.
Wherever this field will from the land acquisition to direct purchase by their negotiated settlement for improvement and upgradation of highways and major district roads under Assam Malapati.
Yes.
Now, there is a lordship has not properly your lordship is the entire scheme
Hmm.
behind. Four onwards, your lordship is high. There is a committee which decides the price.
Page,
9.
clause.
4.7. DLLPC, that's the district that the land purchase company. DLLP.
Yes.
DLLPC will prepare the valuation of land and assets. The requisitioning agency may also define few typical immovable assets of different categories. It fix the guidance price to appropriate authority. Now, this is how the prices are set. If 4.9 your noted times in the parameter, that's the direct purchase price. Now, this is done to basically not follow the right to time compensation at this time country. Now, 4.9 is how the direct purchase price ought to be. The direct purchase price shall be verified by person higher of the compensation calculated as per provisions of section so and so of the 2013 Act with multi-parallel market rate of land defined through Assam Land Acquisition Provision. Now, 4.11 is the pre-informed negotiation with respective landowners will be carried out by the ELLPC. Now, 4.1, the settlement reached in the negotiation shall be recorded as agreement through Form B and C for landowners and for interested parties. So instead of going for that cumbersome process of acquisition, they will involve us, they will fix the direct purchase price, that will be recorded in Form B and C agreement. This is the scheme.
Yes.
Now, based on this, direct purchase prices were fixed for us. There's a bulky set of documents for each of the gardens. Those figures are not disputed. Page 122 onwards, the Lord shall find a sample of how the Form B agreement is executed. Now, here we're going to write this point of one tab. In fact, my category readings are that we were some Form B agreements wherein they were not concluded, though the chart was prepared as regard value. So 122, your Lord shall find.
What was the rate?
This is the rate. The valuation.
Because if we do not put the actual amount, negotiated amount, you can at least
Yes.
mention the rate. Rate would be uniform perhaps.
171. For different areas, it says different rates.
Okay.
But this is in respect of one garden.
Yes.
8 column.
Hmm.
And theta.
Hmm.
Some are less, some are more.
Okay.
Now, one from suddenly payments stopped coming, we surrendered our land. And therefore we reached out with inquired as to what is happening. So 154 is one such letter by one garden. The second paragraph for Lordship C. From me that indicated is in a table that has been denied. So 154, the second last paragraph. And now this is addressed to the district commissioner that now it has come to our knowledge that the government of Assam has changed the compensation amount by reducing it to huge extent. Furthermore, it is not possible on our part to accept land compensation amount less than the compensation fixed earlier at the time of executing the aforesaid agreement. Now, here, another issue is that made also a statement that we were made to sign on dotted lines insofar as the indemnity concept. So the valuations otherwise are on record. Now, page 192, if you're watching, this is the stand of the district commissioner.
Page?
190.
What is this?
In the response, why the compensation? The second paragraph.
Yes, please.
However, the total value of land has been fixed and approved as rupees 91,212 per bighha for Golaghat district by government letter number 25/8/23 as received from the principal secretary to the government of Assam Revenue and DM department. As such, the revised zonal rate of land is taken under consideration for making compensation as per project director so Guwahati by letter number so dated 7/7/23 for the said Appamala project. Therefore, you are requested to vacate the land immediately.
Well, when did you enter into the agreement?
As the,
Can you give the dates? Can you give the dates?
page 6. The different dates because the series of documents.
We'll require the dates. 8,
8/6/2022.
petitioner 1. Please give a list, okay? The dates of the agreement of the who are the first 6 numbers of petitioners.
Some of those there are valuation fees signed by all of the parties. 3 of the petitioners agreements were not well made to sign it and they were not given copies of it. They were made to sign it, but they did not retain copies. That statement of dispute. Around 9, 11 and 19.
Okay.
But at para 45, I indicated the entire.
Para?
Para 45, page 43. At para 9, 11 and 19, that same page was besides that they did not supply us with the copies, though we were made to sign on. All that has not been disputed in the past. So the worship has seen the letter, they have now said that now that the principal secretary, revenue department has fixed a different zonal valuation, we go by that. Regardless of the fact it is an etc. Now that notification has been brought on record by WG. Now lordship has page 277, that is the stand, that is the brief stand. That's there and there. Filed on 1911.
2.
70.
Date? Date.
8, 19.
Not be 277. Affidavit by whom? And position. Yes, starts at 274. And there is only one annexure that is dated 25/8/23. You said another date. That's 279. No, date you had said something else. 25/8/23.
Okay, 190 is referred to this, now this is come on record. The revenue department, by notification was going to introduce the new modality for fixing the valuation of fee charge in land for account. Following the methodology of this notification and with the recommendation of the district level land valuation committee, new rates of fee land valuation have been proposed by the district commissioners in respect of their district. On receipt of the recommendation of state level screening fee, Governor of Assam is pleased to convey the approval to the finalized rate of rural valuation of fee land of your district for the year 2023, which will be effective from 1st of September 2023 till 31/12/2023 as submitted from your end. All concerned to follow and meet the new rates of zonal land valuation from September 1, 2023 for the purpose of registration of immovable property, settlement, land acquisition, and all other matters related to.
Hmm.
This is the summary capital. Now, this entire scheme was made so that they do not have to undertake that cumbersome process of compensation, so it was a negotiated price. Now, one argument perhaps may come that there are no on-the agreements in respect of all the tea gardens. Now, but the fact that the valuation was done, there were valuation sheets for it, there's clear impressions in the affidavit that there's nothing to dispute here factually. Now, only given the fact that they did not follow their own scheme, whereunder they had to sort of execute those faulty agreements, can I be deprived of a compensation? So, of course, there's one judgment by the High Court regarding this very scheme, and they've said that once the fixed prices are agreed upon, you cannot backtrack. Now, that this is confined in page C. In fact, it was discussed here. And then finally at para 15 also.
There are 30. Yes.
However, as it may, under notification price for acquisition in the negotiated price and not the actual cost of damage. Assessment by the state to the executive engineer PWD cannot be the assessment for basis of compensation under the Act of 2015 in as much as in such a case procedure for rehabilitation and resettlement is required to be followed. Above that, under other statutory compensation like solution, etc. are to be added. Further, in an acquisition procedure, landowners shall have a right to claim more amount if they are not satisfied with the award made by the acquiring authority. However, such amnesty is not available under the notification dated for acquisition of land through negotiated settlement. In the considered opinion of this court, the negotiated price has been a price arrived as or accepted by the landowner for the acquisition of their property in state, and therefore the assessment made by the state authority shall lose its relevance in case of a negotiated settlement. As assessment made by the state at best can be assessment for the state for negotiation, in as much as it is a specific feeling of the petitioner that they have agreed to the negotiated settlement on the basis of the price only, and they have no further option to go for an enhancement of such plan. Another aspect of the matter is that once the authorities have agreed on the price and the award has been passed, there shall be no scope to recall such award either under the notification dated so and so or under 64A1 of the Act of 2013 and Rules 2015. That being the position in the considered opinion of this court, the petitioners cannot be deprived of their negotiated right for the acquisition of land through direct purchase. It is needless to say that if state authorities are of the opinion that they paid more price for the wrong assessment done by their officers, they shall be at liberty to take action against those officers. However, they will have no authority under law to make a reassessment for purpose of payment after the price is settled and the award is passed. They also cannot pay a lesser amount than the negotiated price on the basis of such reassessment, more particularly when the price was determined after negotiation with land. The only distinguishable aspect would be here, the documents were in order. In my case, in respect of the guardian, I now concluded agreement. But there are valuation sheets, there is no dispute to the periods as regards the quantum and the figures that were arrived at. Well, to address that aspect, if I may just rely on. So that is the argument that would come in, that there is no concluded contract, that books are not found by it. Can still fall back on the principle of promissory estoppel. But as they enter 1979, the celebrated Motilal Padmavat.
Padampat,
Padampat.
not Padmapat, Padampat.
One has correction to name. And para A. This is a principle based on equity and therefore. Para A color and the relevant, it's a long paragraph, page 19 is the note.
Para
Para A.
8.
Picture part, which begins at page 9. Para on that page.
Pages are not here. Page, yes, it's a, yes.
My therefore seem to suggest that the doctrine of promissory estoppel is limited in its operation in cases where the parties are already contractually bound and one of the parties induces the other to believe that the split rights under the contract would not be enforced. But we do not think any such limitation can justifiably be introduced to curtail the width and amplitude of this doctrine. We fail to see why it should be necessary to the applicability of this doctrine that there should be some contractual relationship between the parties. And so, in fact, Donald pointed in so and so, Lord Case in enunciation of the principle assume the pre-existing relationship between the parties, but this does not seem to me to be essential, provided there is a pre-existing legal relationship which could, in certain circumstances, give rise to liabilities and penalties. But even this limitation suggested by Robinson that there should be a pre-existing legal relationship which could in certain circumstances give rise to liabilities and penalties is not warranted. And it is significant that the statement of the doctrine by Justice Delhi in the High Court Whitefield case does not contain any such limitation. The learned judge has consistently refused to introduce any such limitation to the doctrine. And while sitting in the Court of Appeal, he said it so many times in Indian versus so and so. Counsel for the appellate referred us, however, to the second edition of Texas Powers book on estoppel by representation by Sir Alexander Turner, a judge of the Municipal Court of Appeal. He suggests that promissory estoppel is limited to cases where parties are already bound contractually one to the other. I do not think it is so limited. It applies whenever a representation is made, whether of fact or law, present or future, which is intended to be binding, intended to induce a person to act on it, and he does not act on it. This observation of Lord Willis suggests clearly that the parties need not be in any kind of legal relationship before the transaction promises from which the promissory estoppel takes its origin. The doctrine would seem to apply even when there is no pre-existing legal relationship between the parties, or the promise is intended to create legal relations or affect the legal relationship which will arise in future. And then it's for the so basically, regardless of the fact that there are formed the agreements or not, whether as per that scheme the award was finalized, so long as that representation is not denied, which eventually induced me to surrender my land, it will operate as promissory estoppel. And in the government by the court bench also one very important aspect was taken note of. Once I enter into this arrangement under the scheme, I sort of forego my rights under the Right to Fair Compensation Act. I can't even challenge it later for enhancement, etc. So having almost waived my rights under the Right to Fair Compensation Act and to have entered into this arrangement with the state. So therefore, I am entitled to receive that amount. Is to point out that there has been no denial to those paragraphs in my review. And that's that of the state. It states after that it begins from page 229 to page 232.
Two?
Pardon. Everybody, the district.
Yes.
Paragraph 11 is where I had stated that we were made to sign the agreement where copies were not provided to us. And we were made to sign and document insofar as the indemnity bond is concerned. They have no comments to offer. And more importantly, at page 236.
Just a minute. So first you are saying 232. Paragraph? Yes.
But I have made that statement as regards me being able to sign on indemnity bonds, not being provided copy. And more importantly, paragraph 26 at page 236. Paragraph 45 is not. 45 is that statement where I had. And even otherwise, there's no statement to the effect that there was some foul play or that there was over evaluation of the That is not their ground, but they only defensive. We can't do it as per the earlier threat because now the notification of 25 and 23 has.
Yes. Yes. Mr. Goswami?
This has already been here in force. In fact, so far as the tea garden is concerned, that has already been in force.
But this, yes,
Fine. That was not. But the notification.
but the notification is 25/8/23. The negotiations had taken place prior to that. If you are contending that it was not brought to the knowledge, that may be a correct contention. But you have to show. No, you have to state on affidavit till when if the negotiations had taken place after this notification and ignoring this notification, some other rates have been given, then matter would be different. If you can show that, petitioners may not have a case. 14? No, it is 25/8/23. Fourteen two. Let us see 14.2. That 259. Please read this. Yes, please. 14.6.22. What is this? But if you read this, carefully read this notification, communication of 25/8/2023 at page 261. Please read this, has no doubt has a reference to 14.6, which you have just referred. Please read this at page 261. Fourteen 6/2020, which you have just referred. 14.6 you have referred there just now. Page 215.
The government of Assam is completely affected. We should realize that, even the creation of the, popular system, or the year 2023, we should be affected from 1st September 2023 to 31/12/2023 as of the Congress Act. All concerned follow the lead letter of women in the of September 1, 2023. For the purpose of the decision of female departments of comes limitation all the benefit. But it restrictively followed. Further, where it is restrictively notifying the association of
So the date is September 1st, 2023.
There also no error of the rate is necessary.
Page 154. What is it, 154? Hmm? We are concluding the hearing. Your part is also complete. When? After the judgment. We are concluding the hearing, we are passing a judgment. We do not know what we'll decide. You have assisted. Whatever is there, you have placed before us. Yes, Mr. Anything more, Mr. Musami? Two? Yes.
Legal and circumstances. What try to be legal and then try to. Okay, during the negotiation, although they were not annexed outside, but it was clear from those agreements that it was leaked as per not the peace notification. There were notifications prior to peace also. For the government that, but for the figure. That was not followed.
Now, from where are you saying this?
If not to this. So, last nine first parent.
Hmm.
Which will be effective September 21, 2020.
Hmm.
So there is a 3 year.
Hmm.
Maybe for the prior period loss.
Now tell us what is high fits lower if it's higher, we cannot presume.
Here, what bigger than profit government, declares that they from time to time. This notification is from first September 2023, 31 to 2023.
Hmm.
Now the rate that was negotiated between the parties was, nowhere it was, nowhere lots of finance mentioned, that it was decided on the basis of any such document or rate, which is applicable for freedom. And that is why subsequently this notice.
You were a signatory in that agreement. No, not even public works department. That is it. You know about, you know how it the rate was arrived at. Just a minute, please. Page 277, yes. Yes, please.
I mean, there is a committee law. That committee negotiates the rate with the owner. Submission will be adopted. First, entire concern of the bank is not that, but my submission will be adopted. As public money is involved. Not even grant that opportunity. Whether at the time of negotiation. These particular facts, that for bigger and less, different rates apply. First, we get in the contract. What are the limits? Here we do not, but at least,
Initially, I've asked a number of times whether you're going ahead. You said, go ahead. You cannot, after the hearing, say that you postpone the hearing. You cannot do that. It's nothing peaceful kind of a thing. This will not appreciate, Mr. Nayak. There are so many cases. We asked you again and again, are we going ahead with the hearing? We have to do. No, you have done your part. You have done your part. You have filed your affidavit. You have placed your affidavit. Anything else? Anything else?
we don't need facts.
Mr. Neka, kindly show us those agreements, pages again.
This was coming up. The PWD was also part of the deal.
But, showing the notification of 2021. But in this case, probably 2021 will not apply, 2022 will apply. It's saying your word is the same.
Page,
And as the agreement.
page. 103.
That is one day on the basis of which way it comes, but what's the basis by fixing the rate of plan? That's not.
Where are the calculation says 90? Calculation says?
Yeah.
Or the agreement, whatever.
120.
Yes. One 62.
Valuation credit page 171. That's only valuation page 180. H216 the valuation sheets of the
Two?
the part of the district purchase.
4.2.
4 point. And in fact, even in the new member representative from the requisitioning agent, so they are part. And second, this entire argument that we do not know what the basis of the classification was, it's too late in the day to advance that argument in as much as zonal valuation of fee may not have a relevance since it's negotiated. If they offered a price, had it not been suitable, I could have walked out, they ought to have done it as per the 2050. And so assessment by them would be necessitated only when it's a regular acquisition under the act. Since it is a negotiated price, no matter what materials they bring on record that it was not sort of adequate or it was on the higher side, that would not make any difference to them.
Okay. Okay, I can report you. Doctor. Page 233. What are these? Now, how are these relevant? Yes, yes. No, but, one question you have to, which will arise, if there is a negotiated settlement, no, there has been some breach of that settlement so far as payment is concerned. You fall back to a zonal value. You fall back to a regularized rate for Jirat. He doesn't have an avenue for reference. Had it been a normal acquisition proceeding, either under the old Act or 2013 Act, under section 18 of the old Act or 64 of the new Act, he can go for a reference. He can pray for a reference. He has a scope to make out a case for enhancement of the compensation. He may fail, he may succeed. That's a different matter. But here, he doesn't have that scope. It is not an acquisition proceeding. If it is not an acquisition proceeding, you negotiate. Of course, in a negotiation, you cannot agree upon an exorbitant rate. Rate has to be a reasonable rate. That is why the negotiating, on the negotiating table, it is not done by one individual. There's a committee. Committee not of the district admin committee, even of the other concerning this departments, including the public works department. So it is that committee which had negotiated with a owner of a land who can also refuse to part with the land. Then you can take recourse of the 2013 Act. By agreeing with that, you have bound yourself. Yes, in a given case, if tomorrow it is found that 100 rupee has been agreed to be 1000 rupee, it's a fraud on the system. That you have not pleaded anywhere. That there has been exorbitant. For certain individuals have agreed on a rate which is exorbitant. These are not there. You are falling back on a notification, which is more on the zonal value. We are on a different perspective altogether. That zonal value will assist you to fix a rate so far as acquisition is concerned, not for negotiated settlement. Okay, we'll consider it. Heard Sri B.D. Rega, learned counsel for the petitioner, also heard Sri B. Goswami, learned AG. And Sri Mr. Nayak appears for as what? AG or what? As CPWD. You are also there, madam. One is whom? Okay, hearing is concluded, judgment is reserved. We'll consider.
Attempt to thank me.
No problem. Yes. Yes. Last order is 1811. Which order dated? 29? 29-1. Yes. Hmm.
this one, this is understanding. The present resolution also, just this code. Without presentation, then the not affect the examination of the. Also, this is. It's but. Thereafter, the last. So now, two options are here. One thing we have also prepared on very. This is our. Our case is why not there initially we got not a woman. Initially they might have put down the dumping. We thought they would take away. How it remain? We are contact in the local authorities. Not the officer, they see it. We are not, only contractor was there. They were. Whatever is not there. So contractor was. We are the contractor and he said that we will take it. Then we follow the deputy profile. Kindly have a look at paragraph page 26 and 27. Page 26.
Yes.
Yes, on our presentation. For the page 25. Constitution, this is my deputy profile, additional lighting of circle officer. Emphasis of land for extraction, dumping for change. And imposing that in the petition, the petition on page 25. The now we are supposed to have a very soon for the. It is the after the psychology. Next psychology has reported page 27. Photos are coming in response to our incident by the page 25. This is 24 page 25. Just to then I will come to page 27.
Yes. What has been stated?
This was submitted by Swansea Commission. We provided a letter number services found to be authentic on the inquiry conducted by Alaska. We reported that many of the letters that have been included are very but it was second as custom also. And so, we were particularly right in that in question has actually been utilized for the seasonable cultivator cultivation. It was agriculture. During the execution of that and living under present unique quantity of trade from or ground from the agricultural lands of the state. They were converting the status of the land to the non-agriculture. So they are encompassed by the NSL applicants are suffering severe financial loss. Further, no NSC has been reported to your trade from the details of the this is for the information direction. Then a case edition will file here. This is the our case file. Now they have actually filed, they have admitted. Now since 27, our land has become converted to non-agriculture. We can't do anything. You know, only land, after land, we are depending on the income of the time. Again, is very good. Now they have come and taken their contractor that work quality close. Contractor has done, he can't do it. Because they can try that small thing. That's the book you find out. Now, this people, then I might have been a even they had a good up of locality, and it was employed and fulfilled for the sum. Practice that it was not used for a purpose of good stuff.
Yes. How do you address this issue? Yes, government. The data is for inland water. Okay.
And five by eight is long to make on 23. And 11 and you should also come to page 71.
Just a minute, please. 71.
Figure fact that there is in there. It was to rotate from the parachute. I under consideration for the space BW.
Just a minute, just a minute. 71 is a communication.
Cannot to the work of dredging in the state was awarded to Messrs. Reed Dredging or SB family. While this is not an existing party. Whether in absence of this party, might not any effective order can be. Because we don't have any privilege of contract.
Just a minute, just a minute. No, here what are you trying to show, Mr. Das? 31st of the where page? Oh, Messrs. Rich Dredging.
Because the work was completed and done by Messrs. This dredging product. And our inquiry case effect and immediate position still has been done in their fields. Compensation by a report damage to what extent? That is also very important.
USS? We have called for a report on the complaint of the petitioner. The circle officer is given a report. Based on that report, you make an assessment, complete these matters, finish these matters. Why should the citizen suffer? What a, oh, his state has to pay.
Or workers.
State has to pay. State has.
With the.
You pay, will give you liberty to recover from the erring party. Why should you drag a party who has suffered damage because of some state function? It was a state function. You had done it through some agency. Agency, while doing it, it was not a state function. No, Barak Namabi is not a state function. Mr. Das, check the records. It's a state function. It is done by certain agency. You have incorporated the Indian Water Transport. They have engaged the contractor. Let us not be bogged down by these technicalities. There is a report of the circle officer. We are not asking you to pay this much of compensation. We are asking you to make an assessment, pay the compensation, and finish the matter. If the report was not there by the circle officer, matter would have been different. On fact, you are admitting that yes. Now, will he run after the contractor? See, at those times when a festival or something is held, there is urgency. So you need to do anything so that the event can be held successfully. That is the outlook. Now, after the event, everyone vanishes and some people suffer.
I think some. Plus my video. Get 68.
68.
Whereof for last year.
68. Yes, during the,
It's the product building, the project product by inlays water authorities of India by.
Hmm.
His one by this one by whether it has been done by the region of India or state. But
state will not have any role in having a Barak Namami.
really, you know,
It is not a matter of who will pay, who will pay. The matter is of payment. State exchequer, and how much will be the payment? You make your own assessment. Dumping is there, make an assessment. Or make the land usable.
an assessment has been done by the acceptance.
Okay. Have you put this on record? What is that? No, Mr. Das, we are not saddling you with any amount. It is your discretion, but it has to be arrived at reasonably and fairly. So it's 60, maybe 50, it can be 70. It's up to you. We neither have the expertise to make an assessment, neither we are equipped with the facts, what kind of damage they have suffered. It is on the ground level for you to determine and arrive at a just conclusion. You take this, the basis of this instruction as one of the guidelines. You do an exercise, pay it. How much is the amount? How much land is involved?
Because
Hmm? Whatever is this, we are not saying anything of the amount. You apply your mind and you finish off the matter. Okay. You may not have too much of a role, Mr. Datta. Okay. Understood, understood. Yes. Okay. Okay, we heard 3 H.R.A. Chaudhary, Learned Senior Counsel, assisted by Suleiman. J. Suleiman. M. Suleiman, for the petitioner. Also heard 3 and us, Learned State Council, comma, 3 as Doctor, Learned Senior Counsel for the for the Inland Water Transport. Or Indian Waterways Authority of and its officers. Anyone else? And Ms. J. Hazarika, Learned Standing Council, Revenue Department. Stop. Para. The instant petition under Article 226 of the Constitution of India has been filed with the following prayers. Prayers to put page 14. Para. 4 petitioners. No, the prayers for as per the facts projected in this petition, which has been filed jointly by 4 petitioners, comma, in the year 2017. 3 petitioners. 3 petitioners, oh, sorry, 3 petitioners. No, correct, 3 petitioners. In the year 2017, an event in the name Barak Namami, even a project in the name Barak Namami, was undertaken for dredging / excavation of the Barak Valley. Full stop. In the said exercise, huge quantity of sand, silt, mud, debris, etc., were extracted from the riverbed, and according to the petitioners, comma, those were dumped on the Miadipata land of the petitioners. Full stop. It is the specific case that no kind of any consent was taken from the petitioners for such dumping, and even long after the dumping was done, comma, no steps were taken to remove the same. Full stop. The petitioners had represented before the authorities, and as no concrete steps were taken for payment of any compensation, comma, the instant writ petition has been filed. But Sri Chaudhary, the learned senior counsel, has drawn the attention of this court to certain documents to canvass that there is no dispute on the factual issue. Full stop. He has submitted that on on a representation submitted by the petitioners, comma, a report was called for by the Additional Deputy Commissioner, comma, Kachar, via communication dated 14/10/2022 from the Circle Officer / Assistant Settlement Officer, Katigora Revenue Circle. Full stop. The said report was called for on the claim for compensation made by the petitioners. Full stop. In response to the said communication, comma, a report was issued by the Circle Officer, comma, Katigora Revenue Circle, dated 15/11/2022, wherein the claim was found to be authentic. Full stop. It was stated at an area of land measuring 4 bigha, 3 katha, 14 chatak, covered by DAG number 337, pertaining to second RS Patta number 203 of village Buribail, Part 1, Pargora, that's Jatrapur, belonging to the petitioners, were affected and were rendered unfit for cultivation. Full stop. It was also stated that that the same had occasioned during due to dumping of huge quantity of silt over the agricultural land during the project within inverted comma Barak Namami. Full stop. The aspect of not obtaining NOC from the concerned petitioners was also stated in the said report. Full stop. Para. Sri Chaudhary, the learned senior counsel, has accordingly submitted that the state authorities are duty bound to pay reasonable compensation for the aforesaid action for which has caused immense loss to the petitioners. Para. 3. Thus, the learned State Council has, however, raised a preliminary objection that the contractor through which the work was done has not been made a party, and the present claim has been made on an action of the contractor. Full stop. He has also submitted that factual aspects are involved which may not be able to be gone into by this court in exercise of its powers under Article 226. More so when such facts are disputed in nature. Full stop. The State Council has, however, very fairly placed before this court written instructions dated 10/2/2025 issued by the Assistant Settlement Officer, whereby the aspect of suffering loss by the petitioners has been admitted, and certain assessment and the aspect of making certain assessment has also been stated. Para. 3. As Dr. Learned Senior Counsel for the has submitted that the involvement of his client was only to facilitate the project and would not have a material role in the present claim. Full stop. He has submitted that if any claim is able to be justified, those have to be met by the state authorities. By the state authorities or the contractor. Contractor is a party. Later on implicated. Okay. We'll put it in the rejoinder. Madam, anything you'd like to say? Revenue? No. Sri Chaudhary, the Learned Senior Counsel, in his rejoinder has submitted that the contractor was made a party subsequently and notice was issued to him, in spite of which he has chosen not to contest the proceeding. Para. After considering the rival submissions and the materials placed before this court, it is not in dispute that on account of execution of the project Namame Barak, the land of the petitioners were made unfit for cultivation by dumping of silt, sand, debris, etc. Full stop. The fact-finding report issued by the circle officer would show that the claim of the petitioner is authentic and bona fide. Full stop. The said communication has also stated that the land has become unfit for cultivation and no attempts were made to remove the silt, debris, etc., in spite of a lapse of a considerable amount of time. Full stop. Para. Though the Learned State Council may be right in contending that the aspect of compensation may not be able to be assessed by a writ court, this court has also been, he has also placed before this court a communication dated 10/2/2025 issued by the Assistant Settlement Officer, whereby an assessment also appears to have been done. Full stop. Para. under the aforesaid facts and circumstances, this court is of the view that without expressing the correctness or otherwise of the assessment made, the matter is required to be considered and disposed of by the district commissioner, Kachar, in terms of the report dated 15/11/2022 and the communication dated 10/2/2025. Full stop. The petitioner, is there any representation pending? No. The petitioner where the petitioner is required to file a fresh representation within 15 days from today with a copy of this order to the a copy of the order annexing the earlier, it may be lost, so annexing the earlier representation also. Upon such submission, the concerned district commissioner, Kachar, would examine this, would consider the same and dispose of by passing an appropriate order of payment of compensation on a reasonable and fair rate. Full stop. The said exercise be completed within a period of 2 months, 60 days from the date of receipt of the representation. Full stop. The state authorities would, however, be at liberty to recover the amount from the erring contractor if so advised. Yes. The communication dated 10/2/2025 is made part of the records. You have a copy? Do you have a copy? You make a copy. We have not stated the amount in the communication. We don't want to bind you. It's up to you. Okay. There is an amount. It may be high, it may be low. You don't want to cause prejudice either to you or him. We have not said the amount, so copy will not be given to you. Yeah. Need not see the copy, not necessary. Yes, next. Need to photocopy kore logo.
Item 9.
Means free. Yes. At least before the appropriate bench. Okay, Ritis of 25. You took 4 years to come to the court. Place before the appropriate bench.
Twenty-four subcase.
Yes, please. Cancellation of sale permission. Okay. You have filed your affidavit, Mr. Das? Then why did you file? You should advise your clients. This is not how you give your written comments. Can it be disposed of? Mr. Das? I'll go to DD. Yes. There is mismatch of dark numbers.
condition. That's we are here.
Just a minute, please.
But I don't expect you to be. In all the state permission, the land that is covered by that number. In the previous position, by the government land, and we have nothing to do with that land. And here, they have stated that after the verification, the government that number 537 is different from the that which is the position. So they are also admitting that the that is different, is that is different. So the government that 537 after the declaring that number 537 we can see. I think.
Where do you get the doubt number in 52?
Not 5260, that count 537 to that, the boundary also given, so here 537 that.
Where is the rejection?
Number 8 is cancel. When we wait for this cancel, and say. It was given, that it was cancelled, when we went for engineer, there is the online registration, that it was shown there, that was cancelled.
Where is it? Page 68? NOC was cancelled.
They were. And we, after that, we finally report for the circle officer, that circle or before that for the final law. From there, it went to the circle officer and.
So? Thank you. Second file to some.
Then to CDC, then.
Lord. Just a minute, please. Yes, what do you say?
Is. Below that. However, the land involved in the associate case in very verification. After the associate cases need to be kept. On the report of this revenue circle, everything gets done. Without stating any
He said why it has been cancelled.
But was re-verification done?
That is.
See, Mr. Das, this communication is of April 2025. We are in December. If a re-verification is done, something else has been detected, matter would be different. But otherwise, you cannot reject or not reject, cancel a NOC. No, we ask you to have the instructions. We'll pass an order on this 34/2025. What is the re-verification done? If not done, matter will not keep on extending. We'll have to pass orders.
Stating that after bill verification. So bill verification has been done once before APO of the ALMC. And also here also it is written that after bill verification.
This might be, difficult to buy cancelling. So let me come to it, it's a very short bill.
What is your name?
Yeah.
Heard Sri A.I. Ahmed, Learned Counsel for the petitioner. Also heard Sri N. Das, Learned State Counsel. Para? In the writ petition, comma, the challenge in this writ petition is towards cancellation of an NOC for transfer of land. Full stop. It is contended that such cancellation has been done on irrelevant factors, as there is no mismatch with the DAG numbers with any government DAG. Full stop. In the writ petition, a communication dated 30/4/2025 issued by the circle officer to the co-district commissioner has been enclosed, as per which a re-verification of the land was stated to be required. Full stop. In the affidavit filed by the respondent number 6 on 8/12/2025, this aspect has not been clearly stated. Full stop. 3N as the Learned State Council is directed to obtain specific instructions as to whether any re-verification as provided in the communication dated 30/4/2025 was done and its outcome. Full stop. If such re-verification has not been done, this court would pass appropriate orders towards disposal of the writ petition. List when we give a date. Tell us. On request, list on first week may be difficult. Yeah, first week may be possible on 9th of January. But while getting the parawise comments, you instruct your clients, this is not the way. In that case, we will ask the officers to come to the court. No, sir, the report is by verification by circle. Will you write to the authorities? Item 10, yes. Here for respondent number 6. That will make entire different meaning. We cannot allow you to you have to file an affidavit, file an additional affidavit. Is Mr. If Mr. Khonikor is taking up this point, then you have to rectify it. If he's not taking up, he's taking this point. No, let his affidavit come, then it's up to you. I think you should file an affidavit, clarify this. Otherwise, he'll take advantage. We have seen that. They file a clarificatory affidavit saying that not was left out. Otherwise, Mr. Khonickar will take full advantage. But not, I'll not, we don't take too much of time. We'd like to dispose of. Heard Sri A. Khonickar, learned counsel for the petitioner. Also heard Sri H. Sharma, learned additional senior advocate for the state respondents, and Sri R.C. Saikia, learned senior counsel, assisted by Sri J.P. Borua for the respondent number 6, full stop. While Sri Khonickar, the learned counsel, has submitted that a rejoinder affidavit has been filed, which is not tagged with the records, comma. Sri Saikia, the learned senior counsel, has submitted that due to inadvertence, comma, in paragraph 5, the word not has been left out, full stop, para. Since our rejoinder affidavit has already been filed, comma, such error cannot be allowed to be rectified by hand. Full stop. However, the respondent number 6 may file an additional affidavit to clarify the same. Friday. If they have no case, how could you go through the case? If you have gone through the case, that means there is a case. Are you related? Not related. Okay. Friday, can you file before Friday? Okay. On request list on Friday. Interim order passed earlier to continue till the next date, August. Yes, Mr. Chalia appearing. Hmm?
The refund amount has. Regarding the interest, I have to speak it, the principal amount has to be.
The contempt was for was regarding non-payment or anything. After the contempt, the principal amount has been paid.
Yes, there was a direct for interest also.
Okay. We'll grant you some time, okay? Madam, you are not there on record. No, you are not there on record. Nowadays you are confusing your sisters or what? We do not know whose name we have to put. You are AB and you are MP. N. Okay. But neither of you are on record. Who is SK Sarkar? SK Sarkar is an advocate. In person. Heard Miss A.B. Kayasthya, learned counsel for the petitioner. Full stop. Also heard Sri A. Chalia, learned counsel for the respondent numbers 1, full stop, para. It transpires that during the pendency of this petition, comma, the principal amount has been paid, full stop. However, since there is a direction for consideration and payment of the interest amount, comma, Sri Chalia, the learned counsel, prays for some time to obtain instructions in that regard. Para. List, in view of the above, list after the winter vacations, okay? List in the third week of January 2025, 2026.
Eleven 13.
Notice was issued when, Mr. Knox? When did you enter appearance? When did you enter appearance? Okay, okay. We grant some time to allow them to file. Heard Miss M. Dib, Learned Counsel for the petitioners. Full stop. Sri Dinath, Learned Counsel, has submitted that he and his colleague would be appearing for the respondents. And though time was granted on the earlier occasion for filing affidavit in opposition, he has renewed his prayer for some more time to enable filing of such affidavit in opposition. Para, in view of the above, matter is adjourned to be listed. We give a date, madam. To be listed in the third week of January, by which time the affidavit in opposition is required to be filed. Second week is a holiday because of Bihu. Twelve will come together. Okay.
I didn't really find something.
Yes, Madam Pastor. Oh, okay, okay, okay. Now, list before any other bench. Without me. Why is this? What kind of matter is this? He had some litigation. Family dispute. Pertaining to Borpeta or what? Why don't you settle this kind of matters? Settle it, doesn't look good. Who are your clients, madam? No, who is he? Connected, they are connected. Relatives, I think, relative. Settle it, doesn't look good. Settle it. Before this for any other bench. We'll go before any other bench. And Mr. Dubey, settle these matters. No. Take some extra step. Whatever give and take, it doesn't look good. Colleague of yours is involved who's not with us anymore. Try to settle it. Okay. Settle it. It's been pending since long. Why we should be pending? And we are connected, relatives. Relatives. Okay.
I did 14 to 16. 4 years.
All matters. All matters. Sorry. All matters. 14 matters. We are not adjourning. We'll come back at 2 o'clock. We'll have this.
এটা সঙ্গে করবো Episode কৰি দিছে দেখোন E por conta da pesca? Né? Mensagem essa, né? E liga essa. যিমান লৈ ল'ব লাগিলে মই অনলাইন কৰি দিম তো নাহিলে তো আজি জানা নেকি লৈ লবি কিন্তু আজি এই সপ্তাহতে মই দি দিম তাতে কি হ'ল স্যার কি কথা বুঝুই দেখো তার কোম্পানি টাকা দিয়েছে ছোট না তুমি নিয়ে দিচ্ছ বড় হচ্ছে শুনলি না
Again, it was last opportunity was given to you. As far as
Now, then what is the position now?
position might not, as I am told by higher education, they have abandoned that plot.
Yes.
And they are going for construction elsewhere. But then it's a public project, it's a government land.
No, see, that project has gone. That it will not mean that you are not entitled to have any other project. You can have
Yes.
some other project.
Yes.
Which is of public importance.
Fine.
But their status would be a status of an encroacher.
Yes.
Of government land.
Fine.
You follow the procedure of law.
My lord.
If they are at all in possession, then you follow the procedure of law. You know what to do.
My lord.
If they have not been able to annex any admissible or reliable or any document which words its name as evidence,
Fine.
then even in a notice they will not be able to.
My lord, that notice,
But did you ever issue any notice for eviction?
no, they
One
were asked
notice-
to produce.
Yeah, one notice they have enclosed
Yeah, yeah.
and relied upon that they were asked to produce documents.
Document,
That is not a notice per se under section 18.
but then.
Regulation
they were not-
18.
They were not asked to vacate their land in
Oh.
land.
Now, if you need the land, you vacate, they get it vacated.
Fine. But then by following Salakuti, the judgment of Salakuti, even this notice can be construed to be a notice for requiring them to produce any document.
No, requiring them to produce and requiring them to vacate are having different connotation together. One may not be able to, or one may not respond to a notice whereby records have been called for.
Right.
That will not immediately give you the right to evict them, evict them. You give a notice for eviction if you require the land.
By operation, after coming into the judgment of the Salakuti, with all respect, we have to give them a chance to prove their bona fide.
Where have you done? Where is the intent of the notice?
So that notice might have.
That notice cannot be construed to be this. Come to page 32.
Yes, sir. But then we were not harsh in using that, but the lordship may see.
No, there is
With many,
that is okay, but this notice is of which year?
13.
it doesn't tell you.
You apply fresh mind,
Fine.
apply, issue notice if you want.
Fine.
We'll leave it to you. Okay.
They will submit a copy of this order along with the repetition or any other document they have in possession.
No, it's up to you. Why should they serve?
We'll try, fine.
We'll say that if you want the land or want the land to be for public purpose or anything, you want the land to be encroachment free.
Fine.
You use the whatever law is there.
Fine.
Okay. Or please have your seat. Anything you want to say?
Regarding other two cases, my friend.
Any other submissions, Mr.?
So documents from the repeat issue.
Hmm.
Whereas in our affidavit, in repeat cases in our affidavit, we have stated that this was given to government department and at that time it was encroachment free. In in 1600 also. 1600. I do 1600.
Yes.
Page 77 and actually 30.
1600.
Yes. This is
How many
item-
petitions are
this
there?
is
Three
item number
petitions, sir.
16.
Oh, 4 petitions.
Three.
Three.
What?
This is item number 16.
Oh, there is one IE also. IE 6485, there's an IE. Okay. Yeah, 1600. We have 1600.
Yes, no, your lordship may kindly come to page 79 first, annexure 32. This is the handing over and taking over position.
79.
79 page number. Annexure 32. This is handing over, taking over position. Nineteen 2013.
Nineteen, 11, 13. Yes.
Then lordship, next page number 80.
This was to rural.
Self-Employment Training Institute.
What is UCO? UCO rural.
Director of Rural Center.
What is UCO? Translated copy, you have not given the vernacular, madam.
Lordship.
Then next page lordship. This is the letter of the revenue and disaster management to the deputy commissioner.
So, for rural. Self-employment. Yes, what is it, Mr. Sharma?
This is regarding if the land
Page-
is not utilized within a period of
Page-
3
page-
years.
page-
Page lordship may kindly come to page 77, annexure 30. This is regarding the if the land is not utilized within a period of 3 years, failing which the land so allotted will automatically stand cancelled and reverted back to the government. And the
Just a minute, this 32, and the 36, is 80, 79. 27.
And if you go by the order of this honorable court whereby the writ petition was withdrawn, earlier writ petition. There it was specifically mentioned in that order that because of the noticing the fact that the concerned government land is now allotted to various public institutions, that is at page 76.
Yes. Yes.
Mr. So-and-so, the learned senior counsel pressed for liberty to withdraw the writ petition.
Hmm.
So at that time, the land has already been allotted to the departments for construction of. And at that time, the apparent from all these documents that at that time, the lands were encroachment free. Thereafter, lordship, most probably they have encroached the land and because of this, lordship unable to, in a period of 3 years, unable to construct, so now this happens most probably, lordship. So the social welfare department and this department, lordship, they are not before your lordship, so unable to say whether these lands are within their occupation.
Are you in occupation of the land?
Lordship, as per my last instruction, as of now, I do not have.
Last instruction, how many years back?
Lordship,
5 years.
Probably a year back, Lordship.
5 years back.
Lordship, a year back.
Cannot be.
Lordship, this is a petition which is filed way back in 2014, Lordship. I
So
prob-
because of that handing over of that land, the earlier writ petition was withdrawn. So at that time, it is apparent that there was no encroachment on their part.
If there was no encroachment, they
Because of
could have
the status
easily.
quo order, most probably they are unable to construct anything in the, on the. plot of
What is the
land.
kind of?
Lordship, if there was no encroachment, what was the need of that notice? They ought not have issued that
When they
notice
have
asking
approved
for the.
Just a minute, just a
This-
minute.
When they have approved the circle officer, he has given that notice to produce any document regarding that. to verify whether regarding their genuineness.
Okay.
Lots. In another, the other repetition lordship, that is 1518, that is item number 15. Here lordship page 62. Handing over, taking over.
1518,
Lordship.
just a minute.
Here also we have taken categorical stand in our affidavit that at the time of handing over, taking over, it was enforcement free and it was never been rebutted by filing any return. Letter. Page 62.
62.
It is handed over to the Social Welfare Department for construction of a shelter home for mentally ill persons.
Was it constructed? Not, no construction.
I have no knowledge, most of it because of that. But we have taken categorical stand in our affidavit that at the time of handing over, there was no such any encroachments, and that was not been rebutted by filing any reply to that affidavit.
What is the Salakuddin petition? Citation. Is it reported? It's reported, I think.
Yes. Notice is to be given.
Okay, please write. All these three writ petitions being connected have been heard together and are disposed of by this common judgment and order. Full stop. The subject matter involves eviction of the petitioners from certain plots of land. Para. As per the facts projected, comma, the petitioners were initially residing at Gorukuti near Sipajhar, and due to a flood situation in the year 1950, they had to shift from their original place of residence. Full stop. Madam, have your seat. Residence and had prayed to the authorities for their rehabilitation. Full stop. It is projected that around 60 such families were rehabilitated in a tea garden area, which was requisitioned. Full stop. The said village, tea garden area in the tea garden area, namely Saloipara, which was requisitioned. Full stop. According to the petitioners, comma, they were also paying certain revenues in terms of the so-and-so rules of 1950. Full stop. However, while the petitioners were in peaceful possession, comma, they were issued notices directing for production of the documents pertaining to the ownership, public possession of the land, or otherwise the allotment, if any, would be cancelled. Full stop. In response to the said notices, comma, few of the petitioners had gone and submitted documents, and due to a fire, comma, certain important documents were also gutted. Full stop. The petitioners, a few of the petitioners had also approached the civil court by filing a title suit, which was, however, withdrawn on technical grounds. Full stop. Thereafter, comma, a writ petition WPC 7531 of 2013 was filed, which was also withdrawn due to certain developments, followed by filing of these three writ petitions. Full stop. Para. I have heard Ms. N. Begum, learned counsel for the petitioners. I have also heard Sri H. Sharma, learned additional senior law advocate, Assam, comma, Sri A. Bhattacharjee, learned standing counsel, Revenue Department. Madam, you are also there. But you have not said anything. Huh? You have closed the project. You have closed the project. Did it even start? To close something, you have to start. Did it start at any time? Without starting, you have closed it. Can you close something without starting? You need a thicker frame to read properly. Yes, and you're also for Revenue Department. Okay, technical, Standing Council, Education Department, Technical Education. Okay, Para. Ms. Begum, the learned counsel for the petitioners, has submitted that the petitioners are in peaceful possession of the land in question, and till now there is no notice directing them to vacate the land. Full stop. She has reiterated that the lands were duly allotted and under the rules of 1950, comma, they have been paying the revenue. Full stop. She has also highlighted that though the lands under their possession were sought to be allotted for construction of certain institutions, comma, such constructions did not take place within the specified time, and therefore such allotment has spent its force. Anything?
Regarding the document, Lord, so they have not annexed the original.
And then that will say your contention. The learned counsel has drawn the attention of this court to Rule 6 of the rules of 1950, as per which the revenue requisition amount has been paid. Full stop. She has drawn the attention of this court to the receipts of such payment. Full stop. The learned counsel accordingly submits that the writ petitions may be allowed and the interim orders be made absolute. Full stop. Para. Per contra, comma, Sri H. Sharma, the learned state counsel, has raised a preliminary objection by contending that the documents which are relied upon by the petitioners are translated oblique type copies and the copies of the originals have not been enclosed to any of the writ petitions, full stop. He has highlighted that when this aspect had he has stated that when this aspect was highlighted, comma, the petitioners were directed to file rejoinder affidavit annexing such documents which also have not been done, full stop. He has submitted that there are no records to indicate that any allotment of land was ever done to any of the petitioners. Full stop. He has submitted that in absence of any reliable documents, comma, the claim that any land was allotted to the petitioners cannot be an acceptable proposition. Full stop. He has also submitted that though affidavit in opposition has been filed refuting the claims of the petitioners, comma, no rejoinder affidavit has been filed in any of the cases. Full stop. Para. Supporting the submission of the learned State Council, comma, Sri Bhattacharjee, the learned Standing Council, Revenue Department, has submitted that so far as WPC 6485 of 2014 is concerned, comma, the land in question was allotted and duly handed over to a polytechnic, pura naam to likhe lo ba, page 77 or pura, full stop. In this connection, comma, he has drawn the attention of this court to the certificate of handing over and taking over, which would disclose that at such time there was no encroachment from any quarters, full stop. He has, however, submitted that taking advantage of the status quo of the interim order passed by this court, comma, no, don't say taking advantage. He has, however, submitted that because of the interim order passed by this court, comma, further construction of the project could not be done, and in the meantime, the period stipulated has also lapsed, full stop. He has informed this court that construction somewhere else? Has it been constructed? No, no, you do not know. No, don't say. Uh, 3 years was there,
It's not fine.
but it is not there in the certificate.
Yes.
It is there in the but last part will not say because you do not know whether it's been constructed. Para. Drawing the attention of this court to the notice annexed to the writ petition, comma, the learned counsel has submitted that such notice can be construed to be a notice under Regulation 18, Rule 18 of the so-and-so rules. And going by the mandate of the Honorable Division Bench pronounced in the case of Salakuddin versus so-and-so, reported in so-and-so, comma, the petitioners are liable to be evicted in case they are in possession, as such possession are prima facie illegal. Full stop. Not says prima facie, ex facie illegal. Para? This court has Miss Mahanta, the learned standing council, technical education, has supported the views and endorsed the submissions made by the Learned State Council and the Learned Standing Council Revenue Department, and has prayed for dismissal of the writ petitions, full stop. She has submitted that so far as WPC. Huh? 6485. 6485 is concerned, comma. There is Polytechnic, we have already said. No, don't say.
Next is one. The order of this code was earlier order.
Hmm.
Yes. Noticing the fact that the concerned government land is now allocated to various public institutions.
Yes, withdrawn, yes.
That also wants to reflect this in the order.
Okay,
I leave it to you.
okay, one moment. The rival submissions have been duly considered, full stop. Full stop, and the full stop, and the materials placed before this court have been carefully examined, full stop. The claim of the petitioners is that due to certain flood in the year 1950, they were rehabilitated in a tea garden area in a village called Saloipara, full stop. Though the claim is that such rehabilitation was done by invoking the rules of 1950, and in support thereof, certain documents have been enclosed to the writ petition, comma. There is not even a single document, the photocopies of which, copies of photocopies of which have been annexed, full stop. This court has found that translated type copies of certain documents have been enclosed, full stop. To a specific query, comma, the learned counsel for the petitioner has submitted that the original documents were returned back to the clients, full stop. However, what is of concern is that even no rejoinder affidavit was filed wherein such copies could have been enclosed, supported by an affidavit, full stop. Be that as it may, comma, as per the projection made, the petitioners are in possession of certain areas of land as indicated in the petitions, full stop. The certificate of handing over / taking over, namely to the Polytechnic, comma, Rural Self-Employment Training Institute, comma, and the Directorate of Social Welfare for construction of shelter home for mentally ill people, would show that the plots of land were encroachment free, full stop. At this stage, comma, Sri Sharma, the learned State Council, has also drawn the attention of this court to an order dated page,
5/12/2014.
in which one?
Page 76, WBC 1600.
Page
76.
When 76 WPC
1600. 2015. Item number
1600, yes. To an order dated 5/12/2024, 2014, passed in 7531 of 2013, in which this court had recorded that the liberty to withdraw the writ petition was prayed for by the Learned Senior Council, noticing that the government land in question was allotted to various public institutions. Full stop. For any reference, comma, the aforesaid order is extracted herein below. Page 76, WPC 1600. Huh? Sarah? In a proceeding under Article 226 of the Constitution of India, comma, a court has to adjudicate a matter on the basis of pleadings supported by an affidavit and the relevant documents duly verified are to be placed before this court, full stop. Such averments, such pleadings and documents are, the respondents are at liberty to refute any such pleadings and also question the veracity of the documents, which appears to have been done in all the three cases by the respondents, full stop. As noted above, comma, the petitioners chose not to file any rejoinder affidavit to the affidavit in opposition and also did not take any steps to bring on record the original copies or even photocopy thereof to substantiate their claim, full stop. In that view of the matter, comma, it becomes difficult for this court to accept the projection that lands were indeed allotted to the petitioners in terms of the rules of 1950, full stop. Para. Having said that, comma, it appears that the petitioners are in possession of certain lands which are government lands, full stop. The notice which was issued earlier has been perused, and the said notice is only on the aspect of production of documents of allotment, which, if not done, would lead cancellation of the allotment, full stop. Though a contention has been advanced that such notice may be construed to be a notice under Rule 18, comma, this court is of the view that to ensure transparency and fairness, comma, a proper notice under Section 18 is required to be issued to the incumbents who are in illegal occupation and possession of government land if there is a requirement to make such land encroachment free, full stop. Para. In view of the above, comma, while this court is of the view that no case for interference is made out by the petitioners at this stage, comma, it is provided that while the writ petitions are dismissed, comma, the respondent authorities would have the liberty to initiate a process for eviction strictly in accordance with law and the principles laid down by the Honorable Division Bench in the case of Salakuddin Supra, full stop. Para. The order of the interim orders stands vacated.
Lordship may say that illegal occupation as claimed by them, because we say that we are there by virtue of allotment.
No, no documents.
Originals are not there.
No, no, even photocopies are
Not
not
there,
there.
it was in their hand.
Even photocopies are not there.
Right. They
Type
didn't turn up.
copies.
I am informed
That
that
we have
they are
stated-
under heavy pressure.
We have stated those.
Yes, they are heavy pressure.
But that much of protection you'll have if they want to evict, they'll have to.
Yes,
do it.
exactly.
Then probably if you have the original, you can produce it.
Yes. Some are already produced copies. They didn't act. Instead, took the person into custody. Then these people are scared of. They are all cultivators, farmers. Now a lot of pressure has been put on them. Deeply obliged.
Should we record your name, Mr. Mahanta? We can.
As your Lordship pleases, my friend has argued it.
He has argued well,
Yeah, I am grateful.
but you are there, will record your presence. K.K. Mahanta, Senior Counsel, assisted by Ann Begum.
Now,
একটু ফাইনাল কপি মোটা দিল হ্যাঁ Yes.
Lordship, morning I made a prayer that for Johnny.
And we had rejected the
Yeah,
prayer.
Lordship, I rejected, and even he's unable to speak. I mean, led by Mr. Prakash. So may I
You do
pray
that case, we are not adjourning
Friday-
case of 15.
No, my lord, we want to do it because they have prepared it. But since due to toothache, we are unable to talk. If your Lordship kindly permit on Friday even, then
You do the matter.
yes, I am petitioner, I am suffering, but I am suffering for the non granting this. So my claim is that I am before
Who is not well? You are not well. You are
No,
okay.
no. The petitioners are suffering for not getting something, and I'm representing them. My senior is not suffering; he's suffering from toothache. So I pray that can it be on
He
Friday?
said, no, we are not required. We are not adjourning. 15 matter, you are not adjourning.
Friday, my lord.
10 years.
Yes, man. Only Friday. Only 2 days, my lord. Because
Not Friday. Okay, tomorrow.
tomorrow.
Tomorrow. They're not adjourning matters at 15. Don't even expect this.
I'm very sorry to say that because it is suddenly it's happened. Yesterday,
Tomorrow, we are giving you 24 hours. Come prepared. Our prayer for adjournment has been made on behalf of the petitioner. Full stop. This court is, however, very reluctant in granting the adjournment as this petition is of the year 2015 and pending since the last more than a decade. Full stop. Para. As an exceptional case, a day's time is granted and the matter is directed to be listed tomorrow.
Man, I will try.
Tomorrow,
No,
no.
we prepare. Much obliged.
Tomorrow, come prepared.
Much obliged.
Made videos. But this is regarding payment of compensation as regard to land minor.
Into page 510 লিখতে দিয়া about 510 এই যে 1950 যে বা করেছিল এইটা Yes, madam.
Please, Your Lordship, as per the order dated 28/10/2025, Lordship, the Sabi Anglong Autonomous Council was supposed to provide us the compensation calculation sheet, Lordship, which on the last day, Lordship, they provided to the APGCL, Lordship. After the APGCL authorities looked over it, Lordship, there was the total balance shown calculation sheet, Lordship, it was not matching with the total calculations, Lordship. So, Lordship, that's why we have sent it for re-verification to the Joint Secretary of Sabi Anglong.
When did you send it?
Lordship, by mail dated 29/10/2025.
Today is 9th of December. We'll fix a date. Very
One,
good.
I have a prayer, my lord. The calculation, the GRAT has not been shown, my lord. That also may be shown because there was a verification, verification, joint verification regarding GRAT also, my lord. Two verifications were doing, one for the land.
When you're doing a re-verification, include everything.
Here, my lord, that may be mentioned, my lord, GRAT has. not.
First, let us see what they are up to. Let us see.
Yes, in this report, my lord, there is no value for GRAT, my lord.
Heard Miss P. Burman, learned counsel for the petitioners. Also heard Miss P. R. Mohan, learned standing counsel, Revenue Department. And Sri, what do you write does?
HR does.
HR does, learned counsel representing the APGCL.
I appear on behalf of Mr. Dina.
Appearing on instruction of Sri D. Nath, standing counsel APGCL. Full stop. Para? Full stop. Sri Das, the learned counsel, by drawing the attention of this court to the order dated 28/10/2025, has submitted that after receipt of the calculation sheet, comma, the same has been sent for re-verification involving the KEAC, correct? Miss So-and-so, learned counsel for the KEAC, has submitted that some time may be granted to her. Recalculation. Has submitted that some time may be granted to her to get the final instructions. Don't say final. Get the further instructions. Para? At this stage, Ms. Burman, the learned counsel has submitted that the aspect of GRAT may also be taken into consideration. Full stop. Para? In view of the above, the matter is adjourned by a week to enable the learned counsel for the KEAC to obtain the updated instructions.
Much all.
Should we give a date? It's a old matter.
Yes, my lord.
Today is 9. Next week will be difficult, madam. Should we try on 17th? Let us try on 17th. 17th. Vacations are from which date? 19 is the last date.
19th last,
Yes.
17th. Much all.
Until 19.
Very good. My lord, two issues involved, my lord. First is, my lord, the assessing authority, my lord. While making the assessment, my lord, did not, my lord, validly exercise the power under section 7A, my lord, of the Provident
That's
Fund.
school matter.
My lord, the school matter, my lord, but thing is that from their affidavit, my lord, certain things has come up that the matter that order was passed ex parte, my lord, and apparently, my lord, no notice was given to us before hearing. That is the issue, my lord. Second thing, my lord, when they have made an assessment, my lord.
We have heard this matter for some length. What was it?
No,
On the last. No, no, then. For 19/8, 2025. Therefore, this court observed that the only issue involving whether this institution or establishment falls within the jurisdiction of this act. So that is the prima facie issue, and that is the actual prayer in the writ petition, your lordship.
no, my lord,
That is the prayer part of the writ petition, your lordship.
I am on that only, my lord. Thing is that they file an additional affidavit, my lord. I am answering to that.
Prayer part is that, your lordship. Earlier once they have approached the honorable court, ultimately by a speaking order, the department disposed of their application. And the application also, the main contention is that whatever exercise has been done, whether it establishment, whether the department has exceeded its jurisdiction, whether the establishment falls within the jurisdiction. That is the prayer in the application also. And according.
At last, 19.8, we had said that prima facie does not appear that it falls under the sixth sense.
We have placed
That document shows itself shows, my lord.
and lordship, 21.8,
Yeah.
This honorable court was pleased to direct us to file an affidavit. We have accordingly filed on filed on 8/9/2025, and there all the documents that earlier I had placed without any affidavit, I have placed here along with the ex parte order 30/12/2014. Now, your lordship, I may be allowed, if I may be allowed to read your lordship.
Yes. When did you file your affidavit?
On 8/9/2025.
Additional affidavit.
No, we file our reply to that.
Reply. No reply regarding that. Denial regarding whether it falls within the jurisdiction or not. Facts are there on here, not lawyer.
6/9, which page, madam?
Page 123 of our additional.
123. What is this?
This is party order. Based on notice of demand and certificates were issued.
Hmm.
Now, may I read it, your lordship?
No,
Now, in this case.
madam, you have to just satisfy, because once we find that we have applied our mind, whether the activities of the petitioner comes within the head, any of the head, that you can show.
No, my lord. The mayor,
Bora, have your seat?
Yeah, madam.
We'll come to it.
Page 117, your lordship.
117.
The first, letter come, whatever it is, can be done that. When, it has been, issued to the establishment by the department concerned. At the time, it has, been allotted a PF code also, lordship.
Hmm.
That document, your lordship. 10/6/1999, your lordship dated. At the time of assessment, the petitioner establishment was getting 23 numbers of employees. But the mandate of this act statute, your lordship. And after on the date also, you have submitted the gazette notification. And as per that gazette notification, your lordship, page 120. It falls under columns 3 and 6 of the gazette notification of 1982. Any school, whether it is recognized by central or state or any institution, 5, column 5 is option. Any institution in which research in respect of any college, whether affiliated or not, any school, whether or not recognized or aided by the central or state, any scientific, any institution in which research in respect of any matter is carried, any other institutional activity of imparting knowledge or training is systematically carried out. So accordingly, this establishment falls within the jurisdiction of the statute, and moreover, your lordship, annexed A of the petition itself states and the power of attorney, your lordship, that has been given by the produced by them, the petitioner side, your lordship, that I have also mentioned. They themselves stated to be an English medium school as per the power of attorney, your lordship. So accordingly, your lordship, In the additional affidavit, you have stated that it is, this establishment falls within the jurisdiction of this statute, your lordship. An English medium school, page 27 of the writ petition, your lordship.
So it falls.
Because they themselves, two documents are there, the 23 numbers of notices. Make sure that the contention of the petitioner side is that after the expiry of 16 years, that 16 years you have explained in the speaking order that the lapse within that period, the department have issued 23 numbers of notices, and admittedly in two of dates, the petitioner side themselves appeared short time. And if your lordship kindly peruses the ex parte order, that is a part of my additional affidavit. It has been clearly stated in para 6 of page 125.
Just a minute, please.
Your lordship may take it from page 124 actually, page para 3 of the ex parte order 30/12/2026. Oh, sorry, 14. Then there are 5 of notice. Party order speaks about that evidence they have appeared dates of time, the petitioner side. And on as para 6 of the party order, somewhere there is a statement, ex parte order by the neither any communication or presentation has been received after 19/2014, nor anyone appeared on behalf of the establishment to represent its case. On contact of our telephone, on 30/12/2014 also, Sri Arunjyoti Gogoi prayed some more time. Thus it appears to me that the establishment has adopted a Fabian tactics and is not interested to represent its case. I find that ample opportunity have been afforded to the establishment to defend its case. As such, I do not find any justification following the proceeding, and hence proceed with the finalization of the proceeding ex parte on the basis of the facts available on record. Para 6 of that party.
All these things you have stated in your affidavit of opposition, additional affidavit.
I have all the and on document.
Okay, we'll have it after some other day. You have filed your rejoinder.
My lord, thing is the main issue is the recovery officer notice, my lord, that I have to have a submission, my lord.
What is it?
That is without any, my lord, jurisdiction 7A, my lord. That is the main thing, my lord. They have to give me a hearing, my lord, before that. No hearing, my lord, from their additional affidavit has come out, no notice was served, no date was corresponded. That is the fundamental right, my lord. Natural justice not given. Earlier High Court directed give a speaking order, that was not given. Secondly, my lord, after 16 years, they make a assessment, recovery officer, On the basis of what, my lord? No material fact. That is the absolutely without jurisdiction. These 2 points, my lord, I have challenged in my writ petition to set aside the, my lord, recovery officer order. My lord. Apparently, till now, my lord, I was wondering, my lord, they will produce the record but in their affidavit. Till now, they could not show.
But he
Any-
says that on 2 occasions you had also appeared out of 23 notices.
what they are contending from their notice, my lord, apparently your lordship will see it is contradicting their earlier affidavit. Dates are not matching up, my lord. Earlier affidavit,
Okay, today we'll not take, we'll have it after the vacation.
my lord, my lord,
But we need to be refreshed with the facts.
my lord, my lord.
Okay, since everything is on record, we can perhaps, there may not be required.
Yeah.
3rd week.
After vacation.
Okay, then we fix a date. It's an old matter.
Yes, my
Okay,
lordship will fix it.
Okay. In terms of, actually, don't put go put.
January
I'm not hard to go.
26.
In terms of the earlier orders passed by this court, the respondent EPFO has filed an additional affidavit which has also been responded to by the petitioner. Full stop. List for the matter may accordingly be listed for hearing on date
22nd, my lord, January, after being vacation,
on 21st of January,
21st.
Tuesday.
Yes, sir.
Online,
Well, interim order earlier.
interim order passed earlier to continue till the next date of listing.
21 is Wednesday, my lord.
22, everything.
20, your lordship may give Tuesday.
20.
20,
20.
my lord. Obliged.
Mar, you for this, I think it could not.
এইটো অকমান উঠাই দিব।
Thank you.